there were some truly early influences. So one is that I had a mother who liked for people to read, especially their children, that there probably aren't many like 13-year-olds in Brooklyn who were reading James Baldwin because their mother thought it was such a good idea for them to, see that point of view. And I didn't think anything of it. It was like, well, of course you read James Baldwin if you're 13 years old. And I had a sister who was a social worker at Mobilization for Youth, which was sort of this left-wing do-gooder kind of thing. And so in my household, there was a lot of that's just sort of sensitivity that, it was just sort of natural. It wasn't that you would read from those other cultures. You would see about cultural struggles. You would deal with the rights of others. My father was a union guy, and that the nature of sort of having some sort of class consciousness, I think, comes from that, and probably in terms of one of the biggest influences in my life was my uncle Harold Kammer, who was identified as a communist by Richard Nixon, one of his proudest moments, a founder of the Lawyers Guild, and with his partner Shapiro, I can't remember his first name, and just listening to him talk and argue with people was big. So he was a lawyer. The fact that I became a lawyer, I attribute a lot to the fact that he was a lawyer. He taught me how to play chess and took me to the duck pond to feed ducks and do that thing. So he had a big influence on me. Well, initially I thought I would do labor law. I thought I would do labor law for unions, actually, which is what my uncle did. But then I took this side turn, I guess. What happened is that in my second year of law school, there was a place at my law school called the Center for Law and Health Sciences, and I was looking for a job, and they wanted somebody who had a background in psychology, which I did, particularly with children, and who knew about the law, which I did, to do some work on kids' rights in getting health care. And so I got that job. And it was, sort of an eye-opener that the field hardly existed at the time, but the fact that there was this entity there that actually thought about these things had a big impact on me. It was like interesting to think about those issues. The people who worked there were interesting. And the following year, the attorney who ran the place, Martha Koster, who then became a private practitioner here, left, and I was offered the job as an attorney. And then George Annis joined it as a director a few weeks after I was hired. There was a grant that came that the Center for Law and Health Sciences had. I don't remember who it was from, but a private foundation, whose job was to teach health law, not just interdisciplinary, but interinstitutionally. And so we had courses that involved students from around the city and Brown University in these areas. And I did start teaching then.
I've actually heard that you taught and, in fact, put together the first course on health law, perhaps in the country.
I think that's probably true.
And as well, you put together the first course on research with human subjects, also in the country.
That might be true too. I mean, I don't know what Jay Katz was teaching before then, but that might have been the first course. If it wasn't the first course, then it was certainly a very early one. The funny story is that when George Annis, who was my colleague by that time, went to the ACLU to say that he was interested in writing a book on the rights of patients, rights of hospital patients, their response to him was, why do patients need rights? Now we know that, prisoners need rights and people on welfare need rights, but why do patients need rights? So that's how inchoate the whole thing was. So when he's referred to as the father of patients' rights, it's certainly true. So I think the notion that the law should play a significant role in medicine and research and social science was really new. I mean, there are no books on it. We sort of had to write our own materials and put things together. And what was fun is that it required you to be a real general practitioner. so that it required tort law, and it required contract law, and it required, some trust and estatey sort of things to see who the family members were who do stuff. So that was great because it's really a field with the application of other fields to do it. So you were allowed to wander. And then you were allowed to wander into another literature. So the fact that you had a group of lawyers reading the New England Journal of Medicine every week was probably a little unusual. And JAMA and all the rest of the journals, the Archives of Psychiatry. So it's fun. So upstairs at the Center for Law and Health Sciences from our office, where our offices were, they were on Bay State Road in Boston, was a forensic sciences group. There were people who went out and investigated every death on a road. So they were like real forensic scientists about what caused these deaths, what people die of, and how could you stop them. And so that was the link, prior to the early 70s, I would say, when medical jurisprudence came to be, that it was forensic medicine, which was what is the impact of medicine on the law? It's the traditional stuff like poisoning and accidents, autopsies. And what was happening is that the focus was changing to what is the impact of the law on medicine. Um, and so it was interesting to see that upstairs there were the traditional forensic type. They had like these disgusting pictures on the wall of dead people, and forensic pathologists love to show people their dead people pictures. They sort of try to gross each other out with them. And downstairs there were people trying to figure out stuff like informed consent and how should the practice of medicine conform to the rights of individuals. So it really was sort of the physical manifestation of the change that was occurring in the focus of the combination of medicine, biosciences, and the law. We as a group were hired by the First National Commission to write the background material on the law of informed consent. Um, it had never been done before, as far as I know. Um, and so one had to go to the basics. And we knew what the Nuremberg Code was. We just didn't know really where it came from. And not that it came from, the doctor's trials, but what was it that people were talking about, and what was the testimony? So interesting, Boston University had one of the few full transcripts of the Nuremberg trials, and we trotted on over to the library and read them. And it was, quite something to say. I mean, certainly up to that point, I mean, everybody knew about the larger trial about crimes against humanity of the Nazi commanders and Gerbling and all of those folks. The fact that there was a doctor's trial was less well known. There were a whole series of other trials too. And so the thing about the Nuremberg Code is like, where does it come from? It's sort of odd that in the middle of a legal case, which is what this is, you have a code. That's not usually where codes come from, right? It's like 1, 2, 3, 4, 5, and it's numbered as a code. And even today, it hardly makes any sense at all that there's a code. It is part of a legal opinion, this code, saying here's what everybody knows. So the question was, where did the judges come up with this stuff? And that's where. And so Leo Alexander sort of made it up. And it's really his code for the most part. There really weren't codes before then. And also, what was quite obvious is that no American physicians were ever held to any similar code, such as that one. And they paid hardly any attention to the code afterwards, too. There's no evidence that it had any impact on the practice of medicine or research after the war. But anyway, that's a long answer to how I ended up with others reading the transcripts, Leo Alexander's testimony. And I have to say that the Nazi doctors, lawyers, were pretty impressive. That the testimony is not an easy testimony. They were very smart. So they pointed out things like, we gave people malaria during World War II in prison. How is that different? So it's hard questions and worth worth reading about. And we were talking to someone about it, some physician who said, I don't like the term the law of, and he wasn't aware that there were books like the law of the sea, right? The law of torts. And so for some reason, George was swayed by that. We called it something else, but the book really is about the law of experimentation. And and when you look at the work of the National Commission, you see that there's a special section, there's a special volume on prisoners, there's a special volume on fetuses, there's a special volume on children. Um, and we did one on the armed services, actually, too. And there may be one or two other things in there, I don't really remember. Um, but we wrote a background for, the legal background for each of those. So for the children's chapter, which I wrote, and I also wrote the fetus chapter and the prisoner chapter. You have to call on other stuff. That there is no work on it. So and what was interesting to me is that when I was originally hired by the Center for Law and Health Sciences, it was to do work on children and medicine. So moving into this piece on research with children was sort of a natural for me. So I already knew a lot about the history of the law of children and the law of children being able to make decisions and the limitations on parents being able to make decisions. So then the question was, how do you apply that here? There was just the beginning of a body of law on transplants, on kidney transplants at that time, or identical twins. Um, that kidneys were being removed from the healthy twin and placed into the sick twin who needed the kidney. And that raised very, very novel issues at the time, which is it okay to take a perfectly healthy kidney out of a child at all? It's just stop there. And does it matter why you're doing it? So the early cases were interesting because of who we think of as children has changed, that the original twins were 19 years old. So the fact that the 19-year-old healthy twin said, yeah, I'm ready and willing to do it, didn't matter because it was an infant under the law at the time. So you have this body of law about children that started out dealing with 19-year-olds, where the courts said, he agrees, that's fine with us, sort of thing. Um, and then there were a few other cases that deal with that. And those were cases which ultimately said that would seem to justify parents consenting to harmful things being done to one child in order to benefit somebody else. And that is the analogy to research on children where there's no direct benefit to them. So you had this starting point that it was possible, at least the court said it was possible. But the analysis was much harder than that because it all happened within families. And when you read between the lines of the court, that seemed to be the decisive factor, not the power of parents or kids. So, um, so when you read those early cases, and there are early cases, it would be hard to conclude that if a parent said, you could take a kidney out of my kid and send it to a laboratory, that they would say fine, even though they would say to take a kidney out of your kid to give it to your other kid. It's fine with them. And so one had to begin to read between the lines and see what the real motivations were, since some people were generalizing to it's okay for parents to take the kidneys out of kids. I think that's true, but only for a very limited reason. Um, and then you get into the issue of sort of the power of families and what family means. So it's very interesting, that sort of thing. And so, these different populations raise different legal questions. So, and they've all been messed with in some way by the medical community. So prisoners had been used as research subjects in a variety of settings. They used to be paid for their blood, and the way they were paid was to reduce the amount of jail time. And so the ethical and the legal question of could you have a state put somebody in prison and then have them buy them back with their body was a important question. And it was important in part because the prisoners were perfectly fine with it, right? If you were in prison, you'd be willing to sell your blood, to get out of prison. You want a kidney? Here, take it. Let me go. It's like not a problem. And so the prison stuff had to do with being in coercive environments, but even more importantly, that they were coercive environments that the state put them in. They weren't, and hence, and so was it okay to take people who were in these coercive environments and let them buy their way to freedom, which is actually the only thing they wanted, um, which they didn't have because we took it away from them. So that raises, those sort of questions of coercion. Fetuses were big because of the Swedish stuff in which they claim that they chopped fetal heads off or something. I'm not even sure if that's true, but anyway, that was the rumor, and um, and so that comes up against abortion politics. That that Tuskegee became public in '72. Roe v. Wade um, was re-argued in '73. People often forget that Roe v. Wade was originally argued in '72, which is the same year that the Tuskegee syphilis study was divulged in the newspapers. Um, but that the immediate thought was to distress women. Right? Women were distrusted all along anyway. They obviously couldn't make their own reproductive decisions. So now, not only would they do that, I mean, the sense, at least of the right to life types, was that any woman who has an abortion doesn't care about fetuses, doesn't care about children. Um, and obviously they would consent to anything. So so one of the interesting things when you look at the federal regs um, is that there's a list of vulnerable populations that the federal regs say if an IRB reviews a trial and the trial involves particularly vulnerable populations, and the populations it lists are prisoners, people with mental disabilities, people who are illiterate, pregnant women, that you look at that list and you scratch your head and you say, how is it that a woman at the moment of conception becomes parallel to somebody with mental disabilities? That why is it that prior to the moment of conception, she was not a vulnerable person, and now that she has conceived, she is? And this notion that it changed women in some way is both odd and disturbing. But obviously, the women don't change. The sense was you can't trust these women. And because after all, any woman who decides to have an abortion must be wanton and uncaring. So the fetal research restrictions are part of the reaction to thinking that, oh, now women are just going to go and have abortions. What do they care, And it's weird. It's like bizarre view of women and women's rights. So, just prior to that, in the 60s, was I don't know if it's the invention, but certainly the wider distribution of effective birth control, oral contraception. And so you had oral contraception, and then you had abortion, and it was like now women were in charge of their sexuality. People didn't really care for that very much. And the idea was how to clip away at it. This is one way of doing that, is saying that these heartless women, shouldn't have a say about what happens to their fetuses or to give up their fetuses in some way. So what's part of that? There was really no evidence that any fetus was abused in the United States or elsewhere, or that anyone has an interest in abusing fetuses. Massachusetts passed a special fetal research statute, which was almost incomprehensible when it was written. I had worked on that and worked with the legislature to try to make it more comprehensible. Um, and the legislature ultimately didn't make it more comprehensible. They just created a procedure by which researchers could go to the district attorney and ask for the district attorney's blessings. As far as I can tell, no one pays any attention to it anymore. Um, but it was a piece of the times that you had a very anti-abortion legislature, that there was a very Catholic legislature and a very Catholic, devoutly Catholic DA who tried to put Ken Edelin behind bars. That was all part of that scene. And you had a very powerful Catholic Church lobby in Massachusetts at that time. And so you have those sort of social forces come to bear. And it's interesting to see that the most forceful regulation of research, even when you look at the research regulations today, is to protect fetuses, not to protect children. That fetuses are much more protected than children are under the regulations. But there were three cases pretty much at the same time. They all pretty much said the same thing. And what's interesting about the cases is they were the beginnings not just of informed consent, but of sort of laying out what constitutes medical expertise and what constitutes patient expertise. So the interesting part of Cobbs v. Grant and Canterbury and whatever the third case is, isn't the fact that they decided that people had a right to give their informed consent prior to being operated on. What was interesting is why they came to those conclusions at that moment. So it's not as if people weren't being operated on prior until 1973. And what the courts talk about are a few things. One is that the nature of medicine changed, that you could do all this stuff to people. So Warren Berger, in one of his typical uninformed moments, commented on how ironic it was that the more doctors could do, the more they get sued. And he didn't consider the fact that the more doctors can do, the more harm they can do. So that, there's no anesthesia malpractice until there's anesthesia. That the thought that that's ironic is just a sign of not being very thoughtful about these things. And it's true. So that, the more poisons one gets, so, chemotherapy is a poison. It's a useful poison, but it doesn't make it not a poison. Surgery and cut people's hearts, it's a risk. So, and, so it used to be that medicine couldn't do very much, so there wasn't much to really consent to. It was not until after World War II that doctors could really fool with people, up to that time. And it was pretty clear what the risks were. So one of the early cases, I think it actually is the Stanford case, is about a woman being treated for breast cancer, interestingly enough, who was burned from cobalt therapy. She was surprised, right? She thought she was going to be treated, and she woke up and her, bones and musculature and all that were like burned away. And, what the court noted is that no amateurs know what those risks are. The doctors do. So we know what the risk is when someone cuts their leg off. It hurts and you're not going to have a leg. But when someone does cobalt radiation therapy, unless someone tells you what the risks are, you have no idea what they are. And so that was the start of it, is that medicine changed, that the risks became much less visible and much less known. And medicine could also be harmful as well as useful, and that the question is who should weigh those risks. So the early cases pointed out that doctors are experts in what the risks are and in balancing those risks, but that they're not expert in determining what risk the individual is willing to take and how the individual assesses those risks, that is a non-expert skill that only the patient has. So it is a nice description of the doctor-patient relationship, that the doctor isn't supposed to, that physicians have to decide for themselves that a treatment is worth doing. But that's their job, is to do that. That doesn't mean it gets done. And the court said once the doctor decides that for themselves, then they need to let the patient in on the secret about what that means and what the risks are. And so it just sort of makes perfect sense. It comes at a time of consumer empowerment, too. It's not just the women's movement, the civil rights movement, but this notion of, informing people about loans, what an APR is, that, the notion that there were consumer rights are all part of what's going on in society at the time, that people should not be acted on, but that people should act for themselves as long as they have sufficient information. It's all part of a changing social scheme. It's an interesting problem. I mean, the whole notion of surrogate consent is a fiction. I mean, obviously, there's no such thing as surrogate consent. So if I say, um, I make a contribution out of your checkbook to a worthy cause, and I say, well, I'm consenting on behalf of Joan, we would go, well, we don't think it works that way. The question is, why do I ever get to act for you? The notion that the fact that somebody becomes incompetent, you can act for them, is a practical one, which is they can't do it. So someone has to do it um, for them. And then the question is, what are the limits? So the thought of just stepping into somebody's shoes and doing whatever they want to do. So if someone is incompetent, we don't let people consent to their getting married, for example, that a third party can't say I do, and now the incompetent person is married to this person. And the challenge is, what are the nature of those what are the nature of those limits? And it also so it has to do with issues of loyalty, right? Not just power. That when you act on behalf of somebody else, how do you act loyally towards that person? So we have a lot of fictions about what consent means and what surrogate consent means. You talk about you have to act in the best interest. Well, obviously that's not true. We never act in the best interest, in part because we have no idea what the best interest of anybody is. That those are just words, right? So that we don't even act in our own best interest because we don't know what they are. That people do all sorts of things that they know are not in their best interests. Um, so, they like marry inappropriate mates. They smoke cigarettes. They, jump out of tall buildings with parachutes. The thought that people act in their own best interest is a fantasy. We have this notion of best interest from child custody cases that the judges are supposed to decide what's in the best interest of the child in child custody cases. But it has been pointed out that's a fiction too, since you can't do what's in the best interest of the child. At that point, what's in the best interest for a child is to have people who love and care about the child, and that what you have is this disruption. But the notion that you can act in the child's best interest at that point is also a fiction. We still use those words. So the words become sort of meaningless. We know that someone has to act, but it doesn't mean that it'll be happy or best. The second thing we talk about, the courts talk about, is substituted judgment. You're supposed to do what the person would want you to do, but no one knows what that is. Right? I mean, in real life, unless someone actually says, here's what I want you to do. And then the judgment, of course, isn't substituted. It's just a person's judgment. So substituted judgment means putting yourself in another person's shoes, which is actually impossible to do. So they're all like guesses, right? And the question of what are we actually doing when we're making judgments for others is, a philosophical as well as a legal question. Um, and the question with parents in particular, children, close family members, is can they act loyally towards the person without letting their own needs get in the way? So that, we hear time and time again of children refusing to remove, elderly parents from tubes and respirators and other extraordinary measures, claiming that their parents would want that they would want everything to be done. That's not what they're doing. What they're doing is they're taking care of themselves. Now, it's entirely understandable that they're doing that. But the notion that they're acting either in the best interest or the substituted judgment of somebody else is not true. They're acting in their own interests. So this is like a very difficult problem. That's why it's interesting. Is what do you do given those facts? And mostly the way we deal with it is consequentially, which is you have the angry or scared or at least vocal child, and you have the unconscious parent. The child will usually win. under those circumstances. But that's just practical. It doesn't mean that we're doing the right thing. So one of the things that we always need to know that we're doing the right thing, or actually even always do the right thing, we should at least know when we're not doing the right thing and do it anyway. If we're going to do it anyway, we need to be responsible for not doing the right thing. I think the polyheme case is a very, very important case, and I think that people don't think about it enough or study it enough, and in part because they like to just sort of shovel it under the rug, if that's the right phrase. Um, it's, to me, one of the darkest things that we've done post Tuskegee. And I'm not a big, oh, this is just like Tuskegee person at all, but this comes really close to that. Um, so polyheme had to do with blood replacement, but some people call it fake blood, which would be a very good thing. That blood has limitations, that it's sometimes infected with viruses. It doesn't last very well. It has to be typed. So if you could have this, so if you could have a fluid, an oxygen-carrying fluid that didn't have those problems, that would be good. So no one denies that. People have been trying to make this stuff for like a lot of years, and it doesn't work. Um, Blood is much harder than we think. And this uh, company, North, what's the laboratory? North something Labs. Anyway, this was its only product, really. It was important for it to get this to market. They proposed a study of people who had hemorrhagic traumas, that they were in hemorrhagic shock, which means they lost so much blood that they were at risk of dying from blood loss. And generally, these people are just put in ambulances and given saline solutions to increase the volume of liquids so they don't die from that. And they're rushed to the hospital and they're given blood. And blood makes them better. What the company wanted to do was, when people were found to have these terrible traumas, that they would randomize these people into two groups. One of them would get polyheme on the way to the hospital, and one of them would get saline. Um, and there wasn't that much objection to that, although there could be objection to it. But that seemed like, there was no blood. There wasn't like they were withholding a known treatment. When they got to the emergency room, the goal was to keep people on polyheme until some amount of polyheme was given to see how it would work. But at that point, the study changed, because what you were doing was withholding a known effective treatment for um, for this terribly dangerous condition that patients had. And so you're withholding without the consent of the individual, because they're in shock. That's like the definition of it. There was no family around to do it. It had to be done very quickly. Um, and the question was it okay to withhold the known um, effective treatment for this in order to see if this other thing worked? And the remarkable thing about this study is that 30 IRBs or so approved it. But even more remarkable to me in this day and age is that emergency room doctors did it. That mostly when we think about research stuff, we think about, oh, what about the consent of the person? We focus on the subject, and we don't focus on the researchers. Um, and it's really just a remarkable thing that you would have emergency room doctors who, of all the specialties, their job is saving people's lives, right? And moving them on. They don't have long, detailed conversations. They don't have lifetime relationships. Their job is to save people's lives, get them out of the emergency room and get them better. That group of doctors were willing to give people stuff that doesn't work when they had the stuff that did work. And that's the part of the study. So that part of the study, as far as I'm concerned, is entirely unethical. It's like scandalously unethical. And but I think we need to think more about why doctors permitted it to happen. That people, as opposed to we need to think about why the IRBs permitted it to happen. The other thing is that there are federal regulations on when it is lawful, legitimate under the FDA rules to do what's referred to as emergency research, although this is research without consent. And the rules were violated in this case. I mean, one of the rules required that there is no standard available treatment, and of course there was standard available treatment. Um, and there was some action taken in Congress to ask the FDA by Senator Grassley why they permitted this, and it all just sort of went away over time. But this is dark, and it's particularly dark because we like to think that the great abuses of research subjects are in the past, and it can't possibly happen again because of the system. And what this shows is that not only can it happen, but people will turn away, right? That nothing happened. That I mean, the stuff didn't work. The company went bankrupt, but the IRBs are doing their IRB stuff. The doctors in the emergency room, they're doing their emergency room stuff. That there were people who were dead because they were in this research who probably would not otherwise have been dead. We don't know particularly who they are, but that's what the data shows, that there's an excess number of deaths in the polyheme group, and that means that people died as a result of being in this study. We don't know who they were because they're so sick that you can't point to any particular individual dying. But in terms of the population part, people died. And we just go, oh, okay. And so, and it's like notable that the regulators, Congress, and others didn't look more deeply at this, the and that so many people were attempting to cover their asses in this by saying, "Oh, it's okay that we did it. We just need to move on." That no one really took any kind of even moral responsibility. I'm not talking about legal responsibility to say, we really shouldn't have done this. I think that terminal illness is a very bad category. Um, you know, not to be like sophomoric about it, but everybody's terminally ill. It's just some people are, more aware of the particular thing they might die from others, but we're all heading in exactly the same direction. We don't like to believe that, of course, um, but we are. The second thing is, but the problem, there are special problems with people who are terminally ill. They're not listed as one of the vulnerable populations, and that is a problem. That, you know, if when women become pregnant, they become vulnerable. Certainly, when people become terminally ill, they become more vulnerable. Um, and it's a population that is easy to exploit. And this goes to the therapeutic um, misconception. And that is, when you're terminally ill, you're desperate. And so you'll do pretty much everything. So I don't know that it's so much. So we focus, I think, too much on the consent part of it, which I think George was doing when he made that comment. Can people in that circumstance give consent? And certainly their consent isn't that free. So he's referring to, I think, Christian Bernard's comment, the guy who did the heart transplant, that, when you come to the point where you needed a heart transplant, you were like someone in a jungle being chased by lions, and your choice was to dive into a river of alligators. And what he said is, it's no choice. It is a choice. It's just not a very good choice, but it's not a no choice. Um, but his point, of course, is that you don't have many good choices to make, and desperation may make you lead to a bad choice. The burden, though, I think should not be on the terminally ill person, the focus. The burden should be on researchers who want to use that person for something to show that there's really something good that may come out of it. We're not just futzing around. And one of the things you see is the reverse, that a lot of people have less regard for the well-being of terminally ill people because they're going to be dead soon. And so the thought is, you can't hurt them, right? Since they're going to be dead soon anyway. So that this is a great population to do research on. And it's not just people who are medically terminally ill. There are people who think, if you're going to execute people, you might as well do stuff to them, in the criminal context, you might as well do stuff to them that you couldn't otherwise do to anybody else, right? Why waste that resource of people who will soon be dead? Um, and so So the question becomes the responsibility of investigators and people who fund investigations about when is it appropriate to actually approach a terminally ill person because they are so vulnerable. So research protection, has to do with rights um, and welfare. And the less people are able to consent, the more vulnerable they are, the more we're obliged to take care of their welfare, right? That's the balance. Um, and um, and that's the part with terminally ill people, especially since they're often that the evidence that we've done anything useful for terminally ill people is essentially not there. That is, terminally ill people, they thought they were going to cure them of their cancer or their stroke or whatever. Um, there isn't much in the way of successes in doing that, particularly true of people with advanced cancers. And so we create new forms of successes in order to validate that. Oh, look, we did this to these people and they lived a month longer. And that's considered a success. That'll get you a front page on the New York Times that, you have a drug that extends, prostate cancer sufferer's life by a month. Um, so George focused on consent. You can't get their consent. I would focus on the use of them by investigators and by others for their own good as opposed to the good of the person. So one of the things we like to do is name things. And we think that by calling things different things, it matters. So we name things learning health, what are they called? Learning healthcare systems. I don't know what healthcare system hadn't been learning prior to calling it a learning healthcare system, or any organization that doesn't learn. Any organization that doesn't learn from what it does collapses. So we now call it something, and it seems to be another category. We call subjects participants as if that matters, that changes the category. So we create a new language to make it think that things matter, and it's a distraction. The So there is certainly a trend to try to have research be less and less regulated, and this is part of that trend. Um, and the argument that's often made, and you see it in the recent work of, I can't remember who it was now, Nancy Cass, I think, yeah, from Hopkins on about research, and talks about how, research isn't more risky than regular medical care. Um, but in my opinion, that entirely misses the point that I don't remember anyone thinking research was more risky. It was just more exploitative. So that if you do a liver biopsy on somebody for treatment, and you do a liver biopsy on someone who can't benefit at all but for research, the risks don't change at all. The risks are exactly the same. The reason why we're concerned about the risk of the non-therapeutic intervention is because that's not how you're supposed to treat human beings. It doesn't have to do with the risk. Um, and we more and more forget why um, we regulate research. And the primary reason is not because of the risk. So if you look at Tuskegee, for example, those men weren't at risk. They were just harmed. It wasn't like a risk of harm. It was like harm. They were used as a means to an end in the most grotesque way, but not because they were at risk. And and if you look at Beecher's work, it's not that people were at risk; they were just misused. That's why there are regulation of research. Um, you know, People like to make believe that research is good for subjects, but it's not true. And people like to make believe that researchers care about subjects as much as their physicians, and that's not true either. And it can't be true. These aren't. Um, this isn't because I think these are bad people. It has to do entirely with social role. So that if you're someone's doctor, you would never do a liver biopsy on them unless they needed it ever, right? You wouldn't even think about that as a possibility because your job is to take care of that person. And if you're a researcher, you will. I mean, even if you're that person's doctor in another context. And because researchers' job, it's not because they're bad, but their job is to use people as a means to an end, is the reason why research is regulated, as opposed to healthcare, in which the doctors are supposed to see the patients as ends, and the patients see the patients um, as ends. So it's very dangerous, I think, for philosophers to be going around saying, and philosophers saying this, the reason why you regulate research is because people can be harmed, as opposed to thinking of the much deeper and much more difficult question of the appropriate use of human beings in order to create benefit for other human beings. The word participant means somebody actively does something. That's what it means to participate. Um, But without saying what they're participating in, it's a word without meaning. I mean, the word participant actually obliterates the role of the person. So principal investigators are participants in research. And if you said, we're not going to call you principal investigators anymore, we're just going to call you participants, that they would be very upset by that. Data analysts participate in research, and they're data analysts. It's only subjects who participate in research who are called participants now. And the thought is that to call people subject demeans them, that they are under the control of another. And assuming that that's true, this is exactly the problem with calling them something else, because it doesn't change what they are. That if subjects are demeaned, then participants are demeaned too. That it doesn't change what they actually do. It just disguises it. So we could stop calling people prisoners and call them participants in penal institutions, but it doesn't make them any less prisoners. Um, so it seems to me that the people who advocate this think that there's something shameful about research, that they are trying to disguise the fact that people are used to a means to an end. And I actually don't have a problem with that at all, as long as everybody knows what's going on, and everybody plays by the rules, that there were times when research is perfectly fine and people are used as a means to an end. But if you think that there's something wrong with the concept of subject, then you have to think that there's something wrong with research, that there's no two ways around it, and that what you have to do is hide. And we hide it in various ways, by the way. We call things like clinical trials, but it's clinical, and it's a trial. It's not actually research. Um, and I think it's unfortunate that people feel that they have to hide it, because I think what subjects do when they're well informed is extremely noble, and that they. So if I were writing, regulations, part of my regulations would say that every research subject has to get a handwritten thank you note from the principal investigator, thanking them for their contribution to this important endeavor, and that they didn't have to do it, and we respect them for doing it. That's what it would mean to respect human subjects, and to understand that human subjects give the rest of us something of enormous value. Um, So participants is just a disguise. And, in part of what we wrote, although the article is unpublished, is um, that the Hastings Center had run an article on brain dead participants. And we thought that that showed you how really stupid the whole concept was, that you could be dead and a participant. It's hard to think about the word participant meaning someone who's actively engaged in something you can do when you're dead, or when you're 1 day old, or any of those folks who are not actively involved. The thought that you're given a pill to swallow makes you a participant is pretty strange. So consent, as we've said, as people have said a billion times, is a process, and it's a process of education, right? The informed part is a process of education, people sitting and talking to each other and answering questions and trying to clearly explain people in language that they can understand. That sort of process is something that physicians have very little practice of doing, that mostly that's not what they are trained to do, and not what they care about doing. Consent forms are supposed to document that went on. So a consent form could say something like, yes, we had this discussion. That would be a document. When I first started out a billion years ago doing this, Mass General Hospital did not have consent forms for anything, for therapies, that doctors wrote notes in the hospital record saying, I spoke to Mrs. Jones and we discussed the following things, which is what you would expect. Um, so hospitals have come to love forms of all sorts. People have come to love forms of all sorts. Everybody, and if you think about how many forms you look at and sign, away on a regular basis, you realize how useless they've become. So that, there's not a person who has iTunes who's actually read the iTunes contract, and it's not there in order for people to read. It's there to protect iTunes, and the car rental contracts are there to protect the car rental agencies, and that's what forms have become, and that's what consent forms have become. So the other day in my IRB, I actually saw a 36-page consent form to something which wasn't particularly complicated at all. And so there were a couple of things. One is that no one reads anymore. No one reads certainly more than a paragraph. If it doesn't fit in 140 characters, or if it doesn't fit on a screen before you have to scroll down, you won't read it. Um, and the thought that anyone will actually read these forms is ridiculous. And there's a couple of reasons. One is that the length, and the other is that they're entirely uninformative, that they are just a data dump and don't at all respond to what people are interested in and need to know. So forms that list all the risks of drugs, and they do that now, drug by drug, are not informative. It just tells you everything that could happen to a human being, whether it's likely to happen, might happen, or is a serious problem. They don't say. And it entirely ignores even the federal rules that said the reasonably foreseeable risk should be disclosed. Not every risk, but we disclose every risk, which is like disclosing no risks. So this is like an old lawyer's trick of saying, all the I want all the files you have about Joan Racklin. And what I do is I find every possible file, scrap of paper, I put it in a van and I dump it. I say, here they are. You figure it out. And that's what informed consent forms have turned into. And so everybody hates them. There's like no one who thinks informed consent forms are any good anymore. And people keep poking them and prodding them and trying to edit them. And so the better thing to do is to do away with them entirely, that there should be no consent forms anymore. And the primary reason for that is not just because they're useful, but if we actually want documentation of what subjects have been told, there are much better ways of doing it. We have no idea when someone signs on that line what they've been told. Um, what we should do is record the consent process, and it should be audio recorded. It's really easy to do. It's really cheap to do now. It means that the people who get others' informed consent will have to consider the fact that someone may actually listen to this at some point. It doesn't mean that the IRB has to listen to each one of those, but they should do it sort of randomly, and people should know that the stuff is monitored, and if there's ever a question, we would have it. But it would force people to think about their conversation, knowing that they're recorded and what's important, and listen to the responses. So this is a problem with having regulations that are as old as they are, that there was no such thing as a digital tape recorder back then. The only way things were documented were with paper. Things are hardly documented with paper. Paper, the idea is that for paper to stop existing, but the regs actually require written informed consent. Um, and that has to change. What the regs should require is documentation, but that doesn't have anything to do with writing anymore.
Hans Jonas, Paul Ramsey, Jay Katz, possibly McCormick. And I wonder if you could talk a little bit about what you learned from some or all of those individuals, and then we'll talk about your role as a mentor.
So, I think the most important thing I've learned from them as a group is that advancement in science and knowledge is optional. That in a technological society, we tend to think that it's ineluctable, and that every advancement is a good thing. And what those writers think about it, what are the costs of doing it? And I don't mean the financial costs, I mean the human costs. And the notion that um, so one of the things in America, and one of the things we see occurring in medicine more and more, is the notion of efficiency. And people act as if efficiency is a good thing. And efficiency is not a moral concept, right? Efficiency is an economic concept. And the fact that people can do something faster or more cost beneficial, in many instances, is good. So that if we can vaccinate children faster and cheaper, um, that's great. Then it becomes an important value, but it's not always an important value. And so the thought that if IRB review takes 2 weeks instead of 3 weeks, I'm just pulling numbers out of the hat, that matters is false, right? And the question is, what does one give up? Or the fact that one should more slowly gather data and analyze it before moving on. People act as if, well, if you do that, you'll be killing people because the cure for cancer is right here. And, if you delay it by 2 weeks, then all these people will die in the next 2 weeks. That's the sort of the attitude, and it's not true. And so efficiency and speed has to be balanced with the dignity of human beings. And that's what all those writers are about. They're all writing about a dignity in some way. They have different ways of measuring it and different ways of balancing it, and they come from different theological and ethical backgrounds. But what they're talking about is dignity, which we mostly have stopped talking about now and started talking about risk. Um, the Impact of Cats is his encyclopedic book. Um, it's the most important resource in the field, and of course it's out of print. But anyone who could lay their hands on it shows you how much was actually known or could be considered in 1972 or 1973 when it was written. So it's encyclopedic and it includes all kinds of things that people never thought about as ethical problems, and he did, and that's one of the contributions. So one of the works that I give my students from his book is an article in Lancet that deals with PKU, with the early investigators trying to figure out what caused PKU, and actually giving a child phenylalanine to see if they could make them have the PKU symptoms. And this was published in Lancet. There's a child who had PKU. They gave her the special diet. She was better. And then not only did they take her off the diet, but they secretly put phenylalanine back into the diet without telling her mother, because her mother was the source of information about the child and they didn't want her to be biased. And so the child immediately went back to all of the terrible PKU symptoms that they have, much to the mother's dismay, as the authors write in the Lancet. You wouldn't see that stuff. If it wasn't for Jay Katz going through essentially everything, yeah, no one would have found that article. His compilation of the materials on the Jewish Chronic Disease Hospital case, no one would see that compilation, would see the testimony. And so not only did Katz give us a ethical notion um, and thoughts about human dignity, but he documented, what had gone on and how easy it is for people to lapse from that. So one of the things that you learn in looking at this stuff is that perfectly good people can do perfectly unacceptable things. That people think that when you criticize research or try to regulate research, that you're saying something bad about them and that they're doing something bad. And the answer is that because of the roles researchers are put in, sometimes they have done stuff bad. So what kind of doctor would ever give a kid phenylalanine to see if who would do that sort of thing? Who would overdose somebody on lidocaine because he wanted to put a tube down her throat that she didn't need? I don't have any reason to believe there was anything bad about those people. They were just carried away by research, which was also the problem with the Tuskegee doctors. They were just carried away by their research. They wouldn't let anything get in the way of it without thinking that, it was wrong. They thought that the science was so important that the ends justify the means. You can't let scientists or researchers make those decisions. They're not capable of making them. We don't come back to the starting point, which is why is it okay to do this at all? It's a human being. So when you think about the history of science, in particular the history of natural science, that humans come into this pretty late in the mix. And so the notion of using human beings solely as a means to an end, and this is Hans Jonas's thing, is troubling. That we're used to, that's sort of the justification for things like slavery. We could use human beings as a means to an end. After all, if you don't have slaves in the South, it'll destroy the economy. It's like that's the argument for slavery, is human people as a means to an end. So the idea of taking people and manipulating them in ways to learn stuff that will help other people is really a pretty extraordinary thing. It's when you really stop and just think about it that way. So why is it okay for someone to put a needle in my liver when I don't need it, even if I say it's okay to do? So we know that consents to maiming are not licit. We know that consents to homicide are not licit. Why is consent to this? So you have this so there is a difficult question to begin with about why is this ever okay? And the answer is always consequential, right? That's the answer because we need it. Um, and I guess that's sort of the best we could do now, the question in regulating it, and we do need it. Don't get me wrong, like I'm in favor of polio vaccine. It's like a good thing. I'm in favor of advancement of science and health and welfare. Um, Part of it is, though, is what we do really vetted enough to know whether or not the advancement can actually justify using human beings as subjects. And the the other thing is that it's good to let people know that they're doing something for the community, even at their own risk. That's like a good thing, which is why informed consent is important. That they need to know that they're doing it for a community, that they're not doing it for themselves. So in a sense, the way I view it is that human subjects, at least human subjects that consent, um, are gift givers, that they give gifts to the rest of us. That's why they should get thank you notes, by the way, in my um, my new regulations. That you give us something, we're going to thank you. And but you can't be a gift giver unless you know that that's what you're doing, right? If you think you're paying a debt instead of giving a gift, then you're not giving a gift. So the notion that that has come up in some writings that people should be obligated, right, to be research subjects is like entire nonsense. It's like a ludicrous perspective as far as I'm concerned. It's not worth even discussing because people aren't obliged to give gifts. What makes it a gift is that it's voluntary and that it's heartfelt. So for an investigator to go into a potential subject's room and say, I'm here because I'd like to do you. I want you to do me a favor. I know that a lot of people who come through this door are people who aren't here to do something for you, but I'm really here to ask you to do something for me. Um, Changes the entire nature of that relationship. It's not, let me make believe I'm going to do something for you. This may cure your whatever, right? Even though everyone knows it's not going to cure their whatever. So the change in the human interaction between saying, I'd like you to do, I would really be appreciative if you do this to me. Um, it puts the subject in control. The subject should be the one who is in control. And it treats the subject with utmost um, respect by saying, you can make a contribution, and that's what it is. And if you don't want to do it, that's fine too. that they're selling Girl Scout cookies, essentially, although the Girl Scout cookies taste better.
Henry Beecher um, famously wrote in the New England Journal in June of '66 that he felt that the best protection for human subject was an intelligent, informed, conscientious, compassionate, and responsible investigator or researcher. Mm. And research has changed a lot from the age when the PI created a hypothesis, and we now have a new face of research and a new role for researchers. And I wonder if you talk about that change and what you see as the PI's current role versus the old days with the Beechers.
Well, let me comment on the Beecher thing first, and then I'll comment on the second thing. I think Beecher's wrong, and that, what Beecher is referring to is what we think of as virtue ethics. You just have to have good people doing good things without understanding that, not understanding is the wrong word, without taking into account that people are formed by their circumstances, in that what's considered a good thing or not a good thing depends on who you're hanging out with. So winning the Nobel Prize is a good thing. And people hardly ask, so did you get informed consent before doing your Nobel Prize winning work? It's a population of researchers, and it's good that they care about the science and all of that. But we have to keep in mind that subjects who say, no, I don't want to do it, are seen as getting in the way. And you can't expect people who need those people to say yes to be the appropriate requesters of the gift. So I start off with the proposition that all researchers are good. Not that all researchers are bad, but that they're put in a position, right, where um, just because of their position and because of their social role, that they see things differently than other people might see things. That's true of all of us, by the way. We're all, um, how we see things. It has to do with, where we sit, where we stand, what's important to us. So anyway, so I think Beecher's idea that, what you just need is good people, assuming that that's true, it's going to be hard to measure them. Um, and it neglects the point that good people are capable of doing not good things at times. What is interesting to me is that no one, while people have fallen all over themselves to turn subjects into participants, that no one has suggested that principal investigators should no longer be called principal investigators. They should be called like research clerks or research runners or something like that. Because the people in institutions who are referred to as principal investigators are neither principal nor investigators. That if you think of an investigator back in the olden days of the 70s as someone who comes up with a hypothesis and creates data collection models and statistical models um, and runs it in a small laboratory, those are principal investigators. Um, Today, much, if not most of the research that's done in medical settings in hospitals is created, the hypothesis is created by someone far away, that the protocol is created by someone far away. And in fact, when suggestions are made in changes of the protocol, the quote unquote local principal investigator often says, I can't do that because there's somebody out there who has told me what to do. And so they play a much more, and the word that comes to mind is clerical role, in that they're told you draw 3 tablespoons of blood, you draw 3 tablespoons of blood. It doesn't require any discretion on the part of the local person, the local doctor. So I have no idea why they should be called principal investigators. But the principal investigators are the people sitting in the NIH or sitting at Merck or Glaxo, or those are where the principal investigators are today. They're mostly not in the hospitals. So by calling them principal investigators, it's deceptive that to go in and say, hello, Mr. Participant, I'm a principal investigator, means that no one has any idea what anybody is actually, what role they're actually playing. I think that the first thing is that commercial IRBs shouldn't be called IRBs, that IRBs are institutional review boards, and they were supposed to exist inside of institutions. So you can't have an IRB that sits in an office divorced from an institution called an institutional review board. So the first thing is that's another thing. They should be called something else in order to try to do. So it might be called, a drug company research review board or whatever it is to make it clear. But it bears little resemblance to what happens in institutions. And and in part it's because the only thing they can do is compliance, right? That their job is compliance. And one of the great shortcomings of the way some of this stuff works now is the thought that human subjects research protection is a compliance issue as opposed to an ethics issue. So people often refer to IRBs as doing ethical analysis, but that's sometimes true, but rarely the case. And it's hard to imagine it's ever the case in commercial IRBs, whose job is to see that whoever the company is, whoever the investigator is, has complied with the appropriate federal regulations. And to me, that's a corruption of the process. One of the, um, I think one of the important things that institutional IRBs have that people forget about is they have so the word is that, gee, the institutional IBs know the community better and the community needs better and that sort of stuff. I think that's all baloney. I don't think any of that is true. What I think is true is that IRBs know the institution better and that they know who's doing the research better, right? And they know who is the more capable and the more responsible and who is less capable and less responsible. And they repeatedly see the same investigators, people who call investigators, applying over and over again and know their shortcomings. But they also know things like um, if it says you have to do an X, Y, and Z kind of scan, that kind of scan doesn't exist in the institution, or that there's no one in the institution who uses that kind of scan, or asks how will it be paid for, since there's nothing in here about payment of some of these things. And so those are surprisingly important things to know. Where will they park? I mean, things that seem so trivial. Um, when they're paid, are they going to be paid like in cash or check? Can they go to this office and get it, cashed? So those things really matter. What sort of the institutional abilities are, what the individual abilities are, and who in the institution. So, we ask our own pharmacist. So, are there any sort of pharmacy issues that this raises in terms of um, distributing the drug or holding the drug or mixing the drug? But we have like the university's pharmacist there to ask them about that. That's why you need institutional review boards, that it's much more than compliance. It's about, can you do this safely? Which is ultimately what an institutional review board should be asking, in addition to the rights question. So I think that institutional review boards are much better able to protect the welfare of people in addition to their rights. The way professionals learn to act is from their senior mentors. And they care about what their senior mentors care about. And if you have senior mentors, as many people do, who only care about getting the most papers published in the shortest period of time, then you have shortcuts. If you have senior mentors who actually care about the ethics of this stuff, then you will care about it too. So the question then is, how do you get the senior mentors to care about it? And the answer is, I have no idea how you do that. So we even see in Prima conferences and other conferences that the place doesn't fill up with physicians and PhD scientists, that they, for the most part, see this as a barrier um, to their work because it is. We like to make believe it's not a barrier, um, but it is a barrier. What they would like to do is whatever they like to do, and that's what's true of every regulated industry. And that's why Beecher is wrong, that it can't be left up to the goodness or the ethics of, senior people or people, because they're hard to find. They have other things on their minds. They have other training and other stresses. But I think that there are systems that you could build. So for a while, I mean, if you look in the Nuremberg Code, it says that the obligation to get informed consent is a non-delegable obligation of the investigator. And people have interpreted that to mean they have to actually go into the room and get someone's informed consent. It's actually not what it means. What it means is that you can't use as an excuse that, yeah, I didn't know that we didn't have their informed consent. Um, but the researchers shouldn't be able to get informed consent. That there need to be people who are able to actually explain stuff and who don't have a stake in the outcome of whether or not the person says yes or no. It's hard to know how those people would be paid, but if we cared about it, we would create a method of doing that. So, for example, if we cared about this stuff, that we would build in to the overhead that people get from the federal government or drug companies the cost of actually having advocates do this, and we would say to advocates, if everybody whose room you go into, you come out with a signed consent form, then we know you're doing a bad job. And right now, the way you know if someone's doing a good job is if you get 100% consent forms. When a senior researcher says to a junior person or to a research nurse, go in and consent Mr. Jones, what that means is they're supposed to come out with a signature on a piece of paper. Right? That's what that means. Not make sure he's like fully informed so that if he says no, we can respect that now. That's not what that means.
The IRB system is now almost 35 years old, at least the federal regulations. And I wonder whether you feel that the current system is still viable. And if you were king, what changes would you make to it?
So the first thing I'd like to say is that I would enjoy being king, and I would like people to vote me, select me to be king, if that's how kings become made. So I think it's a hard question, because the question isn't really about IRBs. The question is really about what kind of review should be done and who should do the review um, beforehand. And there are different possibilities, and they all have their strengths and they all have their weaknesses. The weakness of the IRB system, the institutional part, not the outside part now, is that the review is done by people's buddies. People know them and their colleagues, and they also know that this review board will review their work at some point because they're all scientists too, who sit on the board. And so the idea of having excessively stringent review is not something that thrills them. Um, and there's also a lot of oh yeah, I know so and so. She's great. She's great. And that's not the question of whether or not she's great or she wasn't great, that she shouldn't have privileges in the hospital. But the question is still, how much should we look at this? Similarly, by the way, we see people who are like just incorrigible, who, you read their consent forms, you go, oh my God, are we going to really let them talk to anybody about this stuff, since the investigator obviously cares not a whit about anybody understanding any of this. But anyhow, institutional review boards have internal conflicts. And one of the conflicts is that as institutions more and more come to rely on research grants for them to survive, um, there is not explicit but implicit pressure to make sure that grants get done and get through quickly, and that if you give people too hard a time, then they won't be able to apply for grants successfully. I had once suggested, only half jokingly, and the more I think about it, the more I like the idea, is that institutions should swap IRBs. That Harvard can come to BU can go to Tufts can go to Harvard, in big cities, so that they don't know anybody, right? And that they don't have personal friendships, and they don't have to worry about this IRB reviewing their work to do away with that. So that's one possibility. But it's also a way of saying there needs to be more outside perspective. That the fact that the review is still primarily, so if you look at the makeup of IRBs, it requires to have 5 people, and it requires one to be from outside the institution. That's not a proportional thing. It's literally one. So if you have a 60-person IRB, then one person has to be from outside the institution. Um, and I think that there needs to be more non-scientists. I think that what IRBs, so the question is, why are there doctors on IRBs at all, right? If we can put it that way, when you construct an IRB. And the argument is that, well, they know about the stuff, that they're technical experts. And that's true, but that doesn't mean they should decide whether or not something should be done. It's sort of like the informed consent thing. What is the role of an expert? The role of the doctor is to know what the risks and benefits are, and the role of the patient is to decide what she wants to do. The role of the expert is to know what the risks and benefits are, but that doesn't necessarily mean they should get to make the decision about whether or not something is acceptable to be done. Um, and so, and the other thing I would do is I would make it public. I would make every IRB open to the public, and hope that the public actually comes and shows up. And people say, oh, what about trade secrets and that sort of stuff? But that's all baloney. That, we don't sit around talking about trade secrets. And I'm not even sure if there are trade secrets anymore in the world of the internet. Um, but when IRBs meet, they don't say, oh, look, there's this new molecule that was invented, and that molecule might do something. So where you have IRBs across the country looking at Joe's Drug Company's protocol to treat ulcer, and there are 60 sites for it. The thought that the fact that that's being done as a secret is hilarious. That, it's not a secret, and there's no reason why the larger public um, shouldn't know about it. So I think that by opening up membership, now the question is, who will the members be? Who cares enough um, to do it? Should they be compensated? And if so, don't they become part of the problem? Those are all like hard questions. Um, but I think we need to start with the conceptualization that they're not primarily scientific review committees, and therefore should not be governed primarily by scientists. They should be governed primarily by non-scientists, because the judgments that are made are largely non-scientific, or they should be largely non-scientific. Now, every IRB should have to have the expertise available to it, that if there's some pediatric drug or some drug for geriatrics, an oncologist to do it. But so, without going into the specifics, that at the IRB recently there was a interesting discussion on when something benefits a subject. Um, So these are people who have really advanced stage cancers, and the idea is to give them this drug and see if it benefits them. And the question is, should you say to people, this may benefit you? Or should you say to people, we're not doing this to benefit you? Right? And not talk about whether it may benefit you or not, but the purpose is to learn new things. We're not here to benefit.